everyone, and welcome to the second of our tort defences video tutorials. Today we're looking at contributory negligence. In common law, contributory negligence used to act as a complete defence. However, under the Law Reform Contributory Negligence Act 1945, contributory negligence now operates as a partial defence, whereby the courts can apportion blame and apportion loss between the parties. And this makes it a more attractive option to the courts than the other defences, such as valenti, which we looked at last time, which can operate harshly and absolve a defendant of liability no matter how much at fault they may be. Consequently, we can say the defences of valenti non fit injuria and ex turpi causa, which we mentioned previously as well, are perhaps of less significance now. So contributory negligence will often succeed where other defences fail. And we saw that in the case of Revel and Newbury when we were looking at occupiers' liability, where the court preferred to reduce the victim's damages by 2/3 for contributory negligence after he'd been shot when he was trying to burgle a shed. They preferred that to the ex turpi causa. So this defence is quite nice because we can apportion blame. And what we really mean by apportioning blame is that we recognise that the claimant and the defendant are both partly to blame for the damage. So a classic example of this would be when a negligent driver hits someone who's stepped out the road without looking, or if perhaps a negligent driver crashes, but the passenger isn't wearing the seatbelt. In that situation, yes, the driver's at fault, but also you can say the person not wearing the seatbelt is also partly at fault for their own injury. So this defence allows us to apportion the blame and reduce damages, basically depending on the person's stupidity in the incident. If we have a look at Section 1, Subsection 1 of the Law Reform Contributory Negligence Act 1945, it says that where a person suffers damage as a result partly of his own fault and partly the fault of another, a claim shall not be defeated by reason of the fault of the person suffering the damage. Therefore, contributory negligence operates as a partial defence. Just highlighted that for you here. So it shall not be defeated, but the damages recoverable shall be reduced to such an extent as the court thinks is just and equitable. So the court is going to reduce the number of damages that the claimant receives based on how at fault they are for their own damage. And the burden of proof is going to be on the defendant here to show that the claimant failed to take proper care in the circumstances for their own safety and that this was a contributory cause of the damage suffered. So we'll have a look at some cases that help to illustrate this. In the case of Sayers and Harlow, Sayers got locked in a public toilet which was owned by Harlow District Council. So she got locked in a cubicle and she couldn't get out, and she'd been screaming, shouting, obviously, but nobody was around. So what she actually did was she stood on the toilet roll holder so that she could try and climb out of the cubicle. But as you might expect, the toilet roll holder couldn't hold her weight. It sheared off the wall and she fell and was injured. This is one I've got to try not to laugh at. She was okay, but she's suing the council for negligence in having this broken toilet lock, basically. Obviously, the council were at fault, but the court decided that the claimant's damages were going to be reduced by 25% for her own blameworthiness or stupidity in standing on the toilet roll holder. So whatever money she would have got if she hadn't have been at fault was reduced by 25%. So you can see here that the court is apportioning blame between Sayers and Harlow. And in this way, contributory negligence is quite a nice defence because it's trying to strike a balance between the parties. In the case of Froome and Butcher, our claimant wasn't wearing a seatbelt when he was sitting in the front of the defendant's car, and he suffered injuries when the defendant crashed and the claimant was thrown through the windscreen during an accident. You can see here from the principle that the claimant's damages were reduced by 20% on the basis of contributory negligence. This case was decided by Lord Denning, and I'm just going to read you a little bit of his judgment here to help to explain why this decision was made. So Denning said, quote, "Whenever there is an accident, the negligent driver must bear by far the greatest share of responsibility. It was his negligence which caused the accident. It was also the prime cause of the whole damage. But insofar as the damage might have been avoided or lessened by wearing a seatbelt, the injured person must bear some share. But how much should this be?" And at this point, Denning goes on to say that it's difficult coming up with a figure of how much to reduce damages by, but he did in this case give us some guidance on it. So Denning went on to say, quote, "Sometimes the evidence will show that the failure made no difference. The damage would have been the same even if a seatbelt had been worn. In such case, the damages should not be reduced at all. At other times, the evidence will show that the failure made all the difference. The damage would have been prevented altogether if a seatbelt had been worn. In such cases, I would suggest that the damages should be reduced by 25%. But often enough, the evidence will show that the failure made a considerable difference. Some injuries to the head, for instance, would have been a good deal less severe if a seatbelt had been worn, but there would still have been some injury to the head. In such a case, I would suggest that the damages attributable to the failure to wear a seatbelt should be reduced by 15%. But here you can see that he's gone in the middle of those two figures, and he's gone for a 20% reduction. And I think what he was saying there was logical, was that if the claimant has not worn a seatbelt but it made no difference, then obviously we wouldn't reduce the damages. But where not wearing a seatbelt has made a difference to the damage, we are going to apportion blame and we are going to reduce it. But as Denning said, the negligent driver must still bear the greater share of responsibility because he caused the accident. So even though the claimant is at fault not wearing a seatbelt, we should deduct, according to Denning, no more than 25%, because at the end of the day, the accident itself was caused by the defendant. The requirements for contributory negligence are firstly that the claimant failed to take care of their own safety in a way that at least partially caused his or her injuries. So we've seen that in Sayers, we've seen that in Froome and Butcher. And two, that the claimant failed to recognise that he or she was risking his or her own safety, even though a reasonable person would. So again, with Sayers, a reasonable person might have realised it's daft, really, to stand on the toilet roll holder. In Sayers, a reasonable person would have realised you should have put your seatbelt on. We've got another case here on contributory negligence. This is one that personally I really don't like. Badger and the Ministry of Defence. And what happened here was the claimant had contracted lung cancer as a result of being exposed to asbestos. So he was negligently exposed to asbestos, which has been proven to lead to mesothelioma, which is lung cancer, and his widow is claiming for compensation against his employer. The High Court in that case awarded her damages, but reduced them by 20% because the court felt that he'd made his own condition worse by smoking, even though obviously people are aware that smoking is a dangerous thing to do. So I think this is a bit harsh, this case, but again, it does illustrate the principle with contributory negligence that the court can have a look and think, have they done something which has potentially made their own injury worse? There are some limits or special situation that we need to consider with contributory negligence. So children, they are less likely to recognise risky conduct than adults, so we'll have a look at those. The standard for a rescuer, they're going to be compared to other rescuers rather than a reasonable person. And in an emergency, we might have to take more risk as well. So we'll look at some cases that illustrate those points. So if we start off with children then, we've got Goff and Thorns, which was a case where there were two brothers and a sister who were waiting to cross a road. And a lorry beckoned them to cross, sort of called them across, indicated it was safe. And so the children, without looking, walked across the road. And another negligent driver nipped through the gap and seriously injured the 13-year-old child. Now, this defendant who had nipped through the gap and run the child over, he was negligent, but he was raising the defence of contributory negligence. So he was saying that these children were responsible for some of their own injuries because they should have looked themselves and not just trusted this lorry driver who beckoned them across. But this case gave us a very important principle and said that young children can't be held to be contributory negligent. Older children can, but the court felt that this girl had acted in accordance with what would be reasonably expected of a 13-year-old. So in other words, the court thought that most 13-year-olds would trust an adult who is beckoning them across. So she was held to not be blameworthy and she was not contributory negligent, so her damages were not reduced. So children don't appreciate risk the same, so they're less likely to be contributory negligent. And this term's a bit vague here, young children, but young children can't be contributory negligent. If we look at the situation with rescuers, in Baker, the defendant had employed two men to clean a well, and in error, they'd taken a petrol pump into the well, and that discharged carbon monoxide, obviously, into a small space. And the men were in trouble, and a doctor tried to rescue them, and sadly, the two men and the doctor died in the well. And the doctor was held to not be contributory negligent because he'd acted reasonably in the circumstances. So although the defendant was trying to argue, well, it's his own fault, the doctor, for getting in the well, that's a stupid thing to do, the court said, well, no, he's a rescuer. He was trying to save life. He did what a reasonable rescuer would have done. That case is quite closely connected to case on emergencies, Jones and Boyce, and you can see it's an ancient case, 1816. It was reasonable in this case for the claimant to jump out of a carriage which looked like it was about to crash, even though it didn't actually crash. And the court here was basically saying that in an emergency, or what you think is an emergency, a person is going to take more risk. And that's reasonable. It will be unfair to deduct damages in an emergency situation. So where you're a rescuer, where you're acting in an emergency, the court is allowing you to take more risk. When we looked at the case of Froome and Butcher earlier in the video, I talked to you about Denning's quote and him trying to come up with a figure for how much he would reduce damages by. When he was talking about reducing damages for failure to wear a seatbelt, he was really talking about two factors that are taken into consideration. So the judge will look at causation, the extent to which the defendant's own actions caused his or her own injuries, and culpability. They look at the blameworthiness. So the two C's here, causation and culpability. And I think it's useful at this point just to remind you of the case of Revel and Newbury. I mentioned it at the start. We looked at this in occupiers' liability. This case shows quite nicely that the courts prefer to use contributory negligence than use extirpi and than use volenti. So in this particular case, Revell's damages were reduced by 2/3, so significantly, for contributory negligence here, showing that it's a useful defence compared to the older defences.